Today our topic of discussion will be enforcement of fundamental rights, writ jurisdiction and public interest litigation. The Constitution of India, as we all know, is segregated into various parts, and part 3 of the Constitution of India contains the fundamental rights. Fundamental rights, the nomenclature implies fundamental means basic. Those essential entitlements without which an entity cannot exist as a human being. These fundamental rights are contained in part 3, which is also called a self-contained code. Now, why is it called a self-contained code? A self-contained code is a code where the rights and the remedies for the infringement of those rights are there in the same code. Now, let us have a glance on the 6 categories of the fundamental rights contained in part 3 of the Constitution of India. The right to equality, they are contained within Articles 14 to Article 18. Right to freedom are contained within Articles 19 to Article 22. Right against exploitation are there in Articles 23 and 24. Right to freedom of religion are there in Articles 25 to 28. Cultural and educational rights are contained in Article 29 and 30, and right to constitutional remedies are contained or is rather contained in Article 32 of the Constitution of India. Now, about Article 32, our father of the Indian Constitution has remarked, if I was asked to name any particular article in this Constitution as the most important, an article without which this Constitution would be a nullity, I could not refer to any other article except this one, that is Article 32. It is the very soul of the Constitution and the very heart of it. B.R. Ambedkar categorized Article 32 as the very soul of the Indian Constitution. Why? Because it is through Article 32 that we can enforce the other fundamental rights guaranteed to us in part 3 of the Constitution. Now, let us throw some light on these fundamental rights in part 3. They are so important rights that Article 13 lays down that if any law is violative of any of the provisions of part 3, the law will be ultra vires the Constitution and void. If we analyze the phraseology of each of these fundamental rights, starting from Article 14 to Article 32, we will find that each of these rights are negatively ordained. They are more of restrictions on the state than of rights to the people. Let us take an example. Article 14, the state shall not deny to any person equality before law and equal protection of laws. Article 15 lays down no discrimination in general. Article 16 lays down no discrimination in public employment. Article 17 lays down no untouchability. Like this, we will find that there is a no in every article. What does that imply? That implies that it is more of a restriction on the state, on the capricious power of the state, not to take away these rights from the people. It is as it were, we are born with those entitlements. It is only that the Constitution puts some restrictions on the state power, not to take away them. So, these rights which are guaranteed in part 3 can be enforced through a mechanism laid down in the Constitution itself. As I already said that Article 32 lays down right to constitutional remedies. There is another article in the Constitution of India, Article 226, which empowers the High Court to redress the grievance if any persons, in certain cases citizens, fundamental right is infringed. The High Court will provide the remedy through Article 226. But then the ambit of Article 226 a bit larger than Article 32. In Article 226, a phrase or for any other purpose is used. That means one can approach the High Court not only for the infringement of fundamental rights, but also for any other purpose for which no other legal remedy is provided anywhere, and a person feels aggrieved. So, he may approach the High Court under Article 226. Now, let us see the text of Article 32, which lays down right to constitutional remedies. Remedies for enforcement of rights conferred by this part, Clause A, the right to move the Supreme Court by appropriate proceedings for the enforcement of the rights are conferred by this part is guaranteed. The Supreme Court shall have power to issue directions or orders or writs, including writs in the nature of habeas corpus, mandamus, prohibition, quo warranto and certiorari, whichever may be appropriate for the enforcement of any of the rights conferred by this part. Clause 3 lays down, without prejudice to the powers conferred on the Supreme Court by clauses 1 and 2, Parliament may by law empower any other court to exercise within the local limits of its jurisdiction all or any of the powers exercisable by the Supreme Court under Clause 2. The right guaranteed by this article shall not be suspended except as otherwise provided for by this Constitution. Clause 3 of Article 32 enables the Parliament to empower any other court to have jurisdiction to adjudicate in case fundamental rights are violated or certain fundamental rights are violated within its territorial jurisdictional limits. By virtue of this clause, if the Parliament so desires, it can even empower the district courts to adjudicate violation of fundamental rights. And there have been suggestions from certain quarters that some of the fundamental rights, some of the writs may be allowed to be adjudicated by the district courts. That would be beneficial for the litigant public. For example, the writ of habeas corpus. Now, these enforcement of the fundamental rights, they can be enforced through Article 32 or through Article 226. But then, since it is a concurrent jurisdiction of both the courts, can a person aggrieved by the infringement of his fundamental right can approach directly the Supreme Court without going to the High Court? This question was answered in Romesh Thapar versus State of Madras, where the Supreme Court decided that one may come directly to the Supreme Court without going to the High Court. However, the present situation is not that. In Union of India versus Paul Manickam, the Supreme Court has laid down that a person must approach the High Court first and then only he can come to the Supreme Court. Now, what are the appropriate proceedings through which one can approach the High Court or the Supreme Court for enforcement of their fundamental rights? As Article 32 itself contains, through directions, orders or writs. Now, writs are the prerogative writs which were retained by our lawmakers from the English system, and they are the writs of habeas corpus, mandamus, prohibition, quo warranto, and certiorari. Now, these are writs which are borrowed from English law and formal order in writing issued in the name of sovereign or the court. Prerogative power of the king. They were the characteristic of the English courts, the English writs. Now, what does these writs which we follow in India, they contain, or what is the meaning of these Latin expression? The various writs which can be issued for the violation of fundamental rights by the Supreme Court under Article 32 or the High Courts under Article 226 are the writs of habeas corpus, the writ of mandamus, the writ of prohibition, quo warranto, and certiorari. Now, let us try and understand what these Latin expressions mean. Habeas corpus, the meaning of this expression is let's have the body, and this writ is generally issued in case of illegal detention or arrest. So, one who is missing or who suspects that one is illegally detained or arrested by the state police or other forces, he or she may approach the High Court or the Supreme Court for a writ of habeas corpus. The next writ is mandamus. If a person is aggrieved by any inaction on the part of any authority of the state, any authority of the government, then this writ mandamus is issued. Writ prohibition is issued to prohibit any executive or quasi-judicial body to do something illegal. Quo warranto is a writ issued by the court to ask by what authority is one doing this. And writ certiorari is issued by the High Court or the Supreme Court to the lower courts in order to correct some illegality which the court is about to commit, so or has already committed. So, these are the various writs which we have retained from the English system through which the courts provide remedies in case of violation of their fundamental rights. Now, who can go to the court, or in technical terms, who has the locus standi to go to the court for redressing his grievance? The classical rule is a person who is aggrieved only has the locus standi. So, if A is aggrieved by any state authority or by some means and in which his fundamental right is violated or infringed, only A can go to the court, either to the High Court or the Supreme Court. But if A is such a person that he is marginalized, he is poor, he is not aware about the procedures of the court, maybe he is not even aware of his right, then should this grievance or injustice go unredressed? To this, we have evolved a mechanism in our legal system which is known as public interest litigation, and this traditional rule of locus standi is relaxed, and any public spirited person may espouse the cause of this person, or for that matter persons like him, which is in the interest of public, where the person espousing the cause is himself not interested. Pro bono publico. Pro bono publico means out of public interest. This is a development which we have in Indian courts also. Let us try and understand the development of this relaxing the traditional rule of locus standi. If we trace the history, it was first done in the United States of America decision in Gideon versus Wainwright. The genesis of the term public law litigation by Abraham Chase. In India, if we look back, for the first time, the concept of public interest litigation, or rather the seed of public litigation, was sown by the great Justice Krishna Iyer in the celebrated case of Mumbai Kamgar Sabha versus Abdul Bhai. Although the term public interest litigation was not used in this decision, but the seeds of PIL were sown in this decision, in this case, by Justice Krishna Iyer. The term public interest litigation for the first time was used by Justice Krishna Iyer again in the case Fertilizer Corporation Kamgar Union versus Union of India. The two judges of the Supreme Court who popularized PILs, or were rather pioneers of PIL, public interest litigation, were Justice Bhagwati and Justice Krishna Iyer. Now, the object or the jurisprudence behind relaxing this rule of locus standi through PIL or public interest litigation was to bring justice within the reachable ambit of poor, needy and disadvantaged sections of the society or the community. Now, if we look at the cases of PIL, we will find the public interests or the purposes for which PILs were decided or PILs were decided by the Supreme Court in the affirmative were bonded labor matters. Bandhua Mukti Morcha versus Union of India is the case. Neglected children, non-payment of minimum wages to workers, harassment of jail inmates, etc., custodial death, harassment by the law enforcement agencies, atrocities on women, environmental and ecological issues, petitions from riot victims, family pension. Matters where PIL were not allowed or cannot be invoked are landlord-tenant matters, because these are not matters of public interest. Service matters pertaining to pension and gratuity. Complaints against central or state government departments and local bodies, except those which are coming under the above mentioned 10 items, the items which we discussed before. Admission to medical and other educational institutions, petitions for early hearing of cases pending in the high courts and subordinate courts, petitions concerning maintenance of wife, children and parents. Now, let us try to trace the judicial trend in invoking PILs or public interest litigations in India. Rights of under trial prisoners. This was upheld in the celebrated case of Husainara Khatun versus Home Secretary State of Bihar. The pitiable conditions of the overcrowded under trials in the jails of Bihar was taken up by the Supreme Court in this case, and speedy trial is included within the right to life under Article 21 was decided by the apex court in this landmark case law. Protection of environment and ecology is another area. The evolving environmental jurisprudence through PIL is something which is followed by the rest of the world of the Indian judiciary. The landmark case Council for Environment Legal Action versus Union of India, cases like MC Mehta versus Union of India, the celebrated concept of absolute liability evolved by the Indian Supreme Court, which is a matter of study in the various law universities of the world, is a very nice development of PIL in India. So much so that the apex court has decided that the word right to life in Article 21 contains a right to wholesome environment also. Child welfare and rehabilitation, the celebrated case of Lakshmikant Pandey versus Union of India. Gaurav Jain versus Union of India, imposing ban on smoking in public places. the case of Murli S. Deora versus Union of India. Rehabilitation and compensation of victims of sexual harassment at workplace. Delhi Domestic Working Women's Forum versus Union of India. Corruption and scams. Hawala scam, urea scam, fodder scam in Bihar, etc. Electoral reforms. Union of India versus Association for Democratic Reforms are the important landmark cases of public interest litigation in India, which has chartered an entirely new way of relief to people who cannot afford to coming to court because of marginalization, because of poverty, because of being not aware about their rights. Should a person whose right is infringed be deprived from access to justice only because of marginalization? The answer is an emphatic no. And so, under the leadership of Justice Iyer and Justice Bhagwati, the doors of the apex court and the high courts were opened up through the public interest litigation in the form of pill. But then, as there is a flip side to everything, especially in a country like India, we are champions to misuse any provision or any good thing which is evolved by the judiciary or by any other organ of the government. Pill is not an exception. PIL, which is supposed to be public interest litigation, was degraded to by certain sections of cantankerous litigant to private interest litigation, to publicity interest litigation, so much so passe interest litigation. So, the Supreme Court had to apply brakes to this exemplary mechanism by which we could reach justice to the doorstep of the victim. And the Supreme Court observed that people are approaching through pill. In the guise of pill, they are actually advancing private causes, or pills are being filed to occupy the headlines of the newspapers. Maybe someone is planning to take up a political career, or maybe he wishes to stand up in elections. So, public interest litigation started degradation to private interest litigation, to publicity interest litigation, to passe interest litigation. So much so, one had to say PIL pill is not a PILL pill for every ill ILL. The Supreme Court had ultimately to decide to impose exemplary cost for misuse of pill, and that was done by the apex court in TN Godavaram Tirumalapuram versus Ashok Court in 2006, that without any proper reason a pill is filed, heavy cost will be imposed on him. Now, let us throw some light on the nuances of this extraordinary mechanism of ensuring access to justice through public interest litigation. We all know that we have separation of power in the Indian Constitution between the executive, legislature and the judiciary. The judiciary is to interpret the law, the executive is to implement the law, and the legislature is to make the law. And the supreme is the Constitution, the supremacy of the Constitution. So, the Constitution is the creator, the legislature, executive and judiciary are the creators. Now, in the judiciary, we have ensured independence of the judiciary, and the mechanism which we have adopted in our judicial system is known as the adversarial system of justice dispensation, which we have taken from England, from the Great Britain, unlike the inquisitorial system which is prevalent in the continental Europe. Now, what is this adversarial system? In the adversarial system, the idea is that the two adversaries, through their war of wits, shall unmask the truth. The two adversaries meaning, for example, in a civil litigation, the advocate for the plaintiff and the advocate for the defendant, through their war of wits, will try to unmask the truth. In a criminal case, the prosecutor versus the defense counsel, through their war of wits, shall try to unmask the truth. So there are always two adversaries contesting or fighting with each other. But pill is a mechanism where, strictly speaking, there is hardly any adversary. Pill is a public interest espoused by a public spirited person before the court for and on behalf of certain deprived sections of the people whose rights are getting infringed. In other words, it is a grievance against the executive, against the rulers, the ruling class, against the government. But then it is, strictly speaking, it doesn't fit into the framework of the adversarial system. But then why did it become indispensable? And why was it innovated as a mechanism to give justice to the marginalized sections of the people? We have found, or we see, that in India and in other countries also, often the government does not live up to the expectation of certain classes of people, especially the backward people, the marginalized people. Now, these sections of the people, they do not have enough means, or in certain cases, even if they have means, they do not have enough awareness to approach the court to redress their grievance. So, the judiciary, through the mechanism of the constitution, is approached to make them get justice, or the job which was that of the executive is to be done by the judiciary. Now, too much of that is also not desirable in the spirit of the constitution, because the constitution clearly delineates the powers of the executive, legislature and judiciary, and that is also for a purpose, because these three wings of the government, they are separated by the constitution. The powers or the functions are separated because they act as checks and balances for each other. So, if through the mechanism of pill, even if the judiciary is made more powerful than the executive, that may also lead to some topsy-turvy within the meaning of the separation of power doctrine. But nonetheless, it has become indispensable, and where people are suffering, where the executive has not lived up to its expectation, where the legislature is in deep slumber. For example, even after assuring the rest of the world that we will enact a law on sexual harassment in CEDAW in Beijing, the Parliament of India did not enact a law. The judiciary had to lay down the norms for sexual harassment in workplaces in Visakhapatnam versus state of Rajasthan. For all these reasons, pill is a necessity in a country like India, but at the same time, one has to be cautious that we should try and remain within the doctrine of separation of power, so that the three wings are and check and balance to each other. So, none of the wings, the executive, legislature and judiciary, be more powerful than the other, because that would be in the best interest of the constitutional spirit. And Indian constitution is perhaps one of the most elaborate and the best constitutions of the world, which is a subject of study in most of the universities of the world, the law universities of the world. Thank you.